Good afternoon. I would like to thank the Gresham College for inviting me to do this lecture. I'm really excited about the topic that I'm talking about because everybody has an opinion, everybody has a perspective, and it's always good to get one. Today what I'm going to do is I'm going to focus in on looking at the ethics pertaining to physician-assisted suicide, but how that impacts people who may be vulnerable for factors other than just being terminally ill. That's looking at the elderly, the disabled, racial minorities, low-income people, and mentally ill people, looking at the concerns that persons who are proponents and opponents of physician-assisted suicide have. So what I want to do is start with looking at the history and evolution of physician-facilitated suicide in the United States. And I will explain to you in a moment why I'm saying facilitation as opposed to assistance. The current legal landscape in the United States, and then look at the ethical concerns. First, talking about the right to die movement. The battle lines have been drawn in the United States, and I'm sure probably throughout the world when this topic has been broached. On the one side, you have the Catholic Church and other religious organizations, and the American Medical Association, at least in the United States, are strongly opposed to the practice. And on the other side, we have two nonprofit groups, Compassion and Choices, and the National Death with Dignity Center. These organizations have fought the battle in the courtroom that I would discuss in a moment. But they've also fought the battle in the court of public opinion. Because in the United States, legislation that is passed is usually impacted by the opinions that the public have. A prime example is legalization of same-sex marriages. The trend turned when the majority of Americans supported the gay and lesbians' right to marry. So I think we're going to see the same thing in the United States with regards to physician-assisted suicide. Now, they first start with terminology. Opponents of it say it's physician-assisted suicide because they want to conjure up images of doctors going around with needles injecting patients and helping them to commit suicide. They want to focus on that there's an active role played by the doctor, and they also want to focus on the fact that it's suicide, which has negative connotations for a lot of people, especially in the United States, because traditionally it was a crime to commit suicide. And since the person would have already passed away, they could not be punished, so the family was punished. They were not entitled to inherit the property of the person who had committed suicide, and the person wasn't entitled to a proper burial. At some time, they were not entitled to any burial. They would put the corpse on the side of the road and let the animals feast on it so people could understand the gravity of committing suicide. The persons on the other side, they want to reframe the narrative and say it's not about assisting in a suicide, it's about aiding in a death. That the physician as the healer, this is just another component of treating his or her patient to make the transition, because dying is a process. Most people are not afraid of death, they're afraid of dying because it could be long, it could be painful, and that this is the journey that they're taking on with their physician. Now, I use the term physician-facilitated suicide. I will be doing them interchangeably today. But the reason why I came to that terminology, I spent a couple of months in Switzerland researching this area and talking with doctors who actually were participating in the procedure. And one doctor corrected me and said, I'm not assisting in anything. All I'm doing is writing the prescription. I don't even have to be present when the patient takes the medicine. So I'm a facilitator. And I kept suicide because even though in the jurisdictions where it's legal, the physician must write, like if you're dying of cancer, the cause of death cannot be suicide, it has to be cancer. But I think that's kind of semantics, right? Because if you're using the medication to end your life, just taking a lethal dose of medication, then you're committing suicide. So the continuation of the evolution continued to play out in the public. So the phase originally of physician-facilitated suicide in the United States was Jack Kevorkian. And Jack Kevorkian, who was nicknamed Dr. Death, because he believed not only just in assisted suicide, he believed in euthanasia. So what he was doing, he was helping people who were not even terminally ill to commit suicide. And he built this machine, and it's called a death machine, and it would deliver them lethal injection of medication, and they would pass away. He was eventually convicted of second-degree murder when he testified on national television that he had violated the law and participated in suicide. So everybody had this image of, if we legalize this, what we're going to do is give the doctors the opportunity to kill you. Maybe you come in and they don't try as hard once they say you're terminal, and the doctor's evaluating life. And so it's not about choice. It's about the doctor deciding that it's time for you to pass away. Well, the narrative had been changed with Brittany Maynard, and she was 29 years old, diagnosed with inoperable brain cancer. She was living in California at that time. Physician-assisted suicide was not legal, so she relocated to Oregon, and she teamed up with a nonprofit organization, and they did these public service announcements. And she said, it's about choice. And she hit upon a narrative that resonates with a lot of people about how dare the government interfere with my personal right to choose, and pulling from like abortion law, contraceptive law, that the government has said that you have a right to make personal decisions about your body, and this is the ultimate personal decision. So after she passed away, her family, her husband and her mother, they continued to fight to have physician-assisted suicide legalized in California, and they were successful. And the latest public opinion polls show that the majority of Americans support the legalization of some form of physician-assisted suicide. And the groups that involved, when the Hemlock Society, it was about getting a good life and dying a good death. But now you will see in just these signs, it's about controlling your own destiny. And we will see when we get to the statutes, even the names of the statutes progress to reflect the narrative about physician-facilitated suicide. So currently in the United States, everything starts at the top with the United States Supreme Court. And the United States Supreme Court makes a decision on the issue, and then they tell the states what they can and cannot do. So in this respect, there was Washington, the state of Washington, it had a statute said it's illegal to assist in a suicide. Some doctors and terminally ill patients sued in the United States and went up to the United States Supreme Court because they made a constitutional challenge. They're saying, we have a 14th Amendment right to life, liberty, and the pursuit of happiness. The government is infringing upon that right by not permitting us to have assistance in ending our life. The Supreme Court evaluated it, and it said we want to apply strict scrutiny, which is the highest test you can apply to the governmental reason for passing the statute, because you don't have a fundamental right to die. Yes, we have said you have a right to refuse medical treatment. We've said that you have a right to have them withdraw life support. What we haven't said, and what we won't say, is that you have a right to have somebody assist you, a fundamental right to somebody to assist you in dying. And so once the court took a fundamental right off the table and did a rational basis test, the statute was upheld because the state said we're trying to preserve the sanctity of life, and we're trying to protect the integrity of the medical profession. And the court said those were interests that the state had a right to carry out. So then the other argument was, well, what about an equal protection argument? An equal protection argument focuses on you have similarly situated people being treated differently. In this case, they're saying, if you are terminally ill and you go to the hospital and you have to get put on a ventilator, and if they remove the ventilator, you're going to pass away, you have a legal right to say, take me off the ventilator. If you're terminally ill with the same condition and you're at home, you should have a right to say, give me the lethal medication so that I can end my life. The court said that's not the same thing. The court said because in the first case, the underlying illness is what is causing the death. that the doctors are preventing you from dying from what is going to kill you. And the second, you want the doctor to help you die from what eventually may kill you. So the court rejected that. So the courts told the states, you can make it legal or you can make it illegal, but we're not going to invalidate any statute that you apply because it doesn't violate the 14th Amendment in any way. So states started making it illegal explicitly. So there are 5 states that have statutes that say you cannot assist suicide in this state or you're going to be prosecuted for murder, or homicide, or manslaughter. So what they're doing is how they're preventing patients from getting it is they're threatening to prosecute the doctors. And so the doctors are not willing to take the chance and write the prescription. Now, some have said, who would object? Who would know? If the doctor writes out a prescription, but the doctors are not willing to take that chance because the pharmacist would know, family members might know. And so it's not always a decision that people agree upon. So it's been legalized in 3 different ways in the United States. One is public initiatives. And a public initiative is where a group of citizens get together and they get a petition and they get enough names to put their proposed legislation on the ballot, which is different from a referendum where the legislature passed a statute and put it on the ballot for the citizens to approve. So there were public initiatives in Oregon and in Washington. And then the legislature actually passed a statute without input from the public in Vermont and California. Now, Oregon became the first state to legalize it, but Washington was the first state to try. And in Montana, the court said, we won't prosecute doctors for it. So looking at those, and in 2015, there were 25 state bills that were defeated. And they all have said they're going to reintroduce those bills in 2016. So we'll see what happens. So the name, Oregon Death with Dignity, Washington Death with Dignity. So Washington started first. They put forth an initiative on the ballot, and it was rejected by the people. Oregon was watching Washington, and they learned from their experience. And what they did differently was they expressly said, we would not legalize euthanasia or lethal injections. You have to be able to ingest the medication yourself. The Washington Initiative didn't make that distinction. So Oregon Death with Dignity Act was passed by the public. But after the public passed it, the legislature, that was being lobbied by people who opposed it, they issued a referendum on the ballot and told the people, vote to repeal the initiative that you just voted to, because the vote was really kind of close. So they put the initiative on the ballot, but then it helped the persons who were advocating for it because it made the citizens angry. They said, we've already voted on here. How dare the legislature try to do a backdoor to repeal a statute that's been voted on by the people? And so they were soundly defeated in the referendum. And then they turned to the federal government. And they turned to the federal government to say that the lethal medication, the same medication that is used to carry out executions in death penalty states, that's the same medicine that you use to commit suicide under these statutes. Those are considered controlled substances in the United States, and they're controlled by the federal government, by federal law. So the opponents went to Congress and said, aren't they violating federal law if the doctors are prescribing federally controlled substances so people can end their lives? The Attorney General at that time, Janet Reno, she said no. She said, as long as they comply with the mandates of the statute, whatever they're doing is perfectly legal, they can't be prosecuted. As always in the United States, you have a change of administration, you have a change of law for some reason, a change of interpretation. So after the Republicans took over, the Attorney General, John Ashcroft, said, no, you're right. They are violating federal law, and we will prosecute them if they write the prescription. So the case ended up before the Supreme Court, and the Supreme Court said that the federal government was incorrect, that the state, they had sent this issue back to the states, and the government can't do an end around and say you can write the prescriptions because the state says it's legal to write the prescription, but when they go to fill the prescriptions, they can't get the medication. So that was rejected. And so Washington then did everything Oregon did, and they were able to successfully get the initiative passed. Now you see again the name change. We went from death with dignity now to end-of-life option. Because the persons in California campaigned by saying, this is just another option. You can have hospice care, you can have comfort care, you can get treatment, you can have physician-facilitated suicide. It's just another treatment protocol. In Vermont, they were looking at, it's about choice. It's about control. And the governor of California, who is a Catholic, he said he really struggled with it, and he is not sure what he would do at the end of his life, but what he's sure of is that the state should not take their choice away from the citizens. So the Vermont Act went into effect immediately the day it was passed, which is unusual for a statute in the United States. California End-of-Life Option Act is still not effective. It should take effect in 2016, but it's already getting ready to be challenged in court. The unfortunate part about it is if it's never take effect, that some of the people who lobbied for it, they will be dead by the time it gets affected. Now in Montana, physician-assisted suicide is technically not legal because the court doesn't have the authority to make law. They don't have the authority to interpret law. And all they said is that it's not against public policy of the state, and it's you can't convict somebody of homicide because the defense in the state of Montana to homicide is consent. And if I request a prescription for a lethal dose of medication, I'm consenting to you assisting me in passing away. But there still is a possibility that the state can ban it. And so the terminally ill patients in Montana are not as protected as in the other jurisdictions where it's been explicitly legalized by statute. In limbo, Hawaii, nobody's sure because everybody's afraid to test it. In the homicide statute doesn't say it's illegal. They supporters haven't been able to get doctors because they're going after retired doctors now saying, well, you have nothing to lose. Write the prescription, roll the dice, and let's see what happens. So far, they haven't gotten any takers, so it's still kind of in limbo. New Mexico, now remember we said that it's not unconstitutional based on the federal constitution. So this time, doctors and patients looked at the statute that made it a felony and said, okay, what about the state constitution? Because the state has equal protection and due process protections just like the federal government does. And the state can give you more protections than the federal government, the way the system works. So the district court, which is the lower court, said, you're right, it's a protected liberty. You have a fundamental right to die under the state constitution. Now, you don't have a fundamental right to die in Texas, Ohio, but you have a fundamental right to die in New Mexico. So that was appealed by the state. The appellate court, the next level, said it's not a fundamental liberty. We go with the reasoning of the United States Supreme Court, and we say it's banned in the state of New Mexico. The Supreme Court heard arguments, and it's on the 26th of October. They have until June to make a decision, and it's really unclear what they're going to decide, because based on the questioning, they really didn't show their hand. So they were aggressive against the opponents. They were aggressive against the people who were supporting. So that's a wait and see. Now let's look at the statutory provisions. These are the ones from Oregon, because Washington, California, Vermont, verbatim almost copied the text of them. So the first thing you have to do is you have to be capable. That isn't a medical determination. It's a legal term that you have to be competent. The bar is really low for you to be competent because your general practitioner just has to say, well, you have the ability to understand what I'm telling you, and you have the ability to communicate to me your medical decisions. You have the ability to tell me, yes, I would like it. Now, in the statute, there's no requirement that you get counseling unless the doctor suspects that you're depressed. And you've just been told you're terminally ill, who wouldn't be depressed? However, they want more. You have to be depressed, and that depression has to impair your judgment in such a way. And so you would see how that is really an easy hurdle to overcome. Very few people. In Oregon last year, only 2 people were referred for counseling. And you can be a counselor with a psychiatrist or psychologist, and that person just has to say you're now competent, and then you can request the medication. Unlike Belgium, they removed the age restriction. In the United States, you still have to be over the age of 18. Some person said that shouldn't be the case, and I would get into that when we start talking about the ethical issues of it. You have to be a resident of the state, which is what Brittany Maynard did. It's relatively easy to become a resident of a state. Get a driver's license, rent or buy a property, file a tax return, register to vote in that jurisdiction. You have to be diagnosed with terminal disease. And this has been controversial too, because what is terminal? If you're on dialysis and if you refuse dialysis, would you survive 6 months? Because there's a 6-month diagnosis. It has to be incurable and irreversible. Some have argued that renal failure is curable. Dialysis. Diabetes is cured by insulin. Others have said there should not be a component that you would be terminal if you would refuse treatment, because you have a right to refuse treatment. So if you have a right to refuse treatment and you have a disease that will kill you if you refuse treatment, some have argued you should be terminal. And some have also argued about what is the magic number that doctors have with 6 months to live? Because a lot of people, several of the patients have outlived the 6 months diagnosis after they've gotten the medication. You have to make an informed decision, which means you have to understand your diagnosis, your prognosis, that there are other options available to you, that you can have comfort care, that you can have palliative care, that you can have medical sedation. So the doctor has to make sure that you understand. Once you meet the eligibility requirement, you have to request the prescription in writing. And it must be in writing that resembles when you execute a will, in the sense it has to be attested by two witnesses. At least one must be disinterested. That means we can't have all your relatives who may inherit from you in the room saying, yes, I think that you should do it. You have to be somebody who's objective, that won't benefit from your death at all. At least one of the persons has to be. Then you have to have a second opinion, and the diagnosis has to be confirmed. Then there's an additional 15-day waiting period. And then you have to ask for the medicine in writing. You can rescind your request at any time, even once you're mentally incompetent. You can still say, I changed my mind, I don't want the medication. And once you get the medication, nobody forces you to take it. Some people, in Oregon last year, somebody had requested the medicine in 2012, and they didn't take it until 2014. But at the time that they requested, they had 6 months to live. You do the math. So ethical concerns. Some say that people who are included but are not protected are the elderly, people who are physically disabled, mentally ill, low-income persons, and people of color. Even people who oppose it, saying if you're going to do it, then you should be all-inclusive. Because if you want to stop pain and suffering of terminally ill people, what about minors? 18 is not a magic number to stop feeling pain. If you have 6 months to live and you're in this horrible pain and you're 17 years old or you're 75 years old, people have argued, what's the difference? Non-terminal patients. The number one reason why people say they select physician-facilitated suicide is the loss of autonomy. Well, you can think of some diseases that are not terminal where you lose autonomy. In my work in surveying people, the number one reason why people would do it was a diagnosis of Alzheimer's. They say they would rather be in constant pain than have a mental breakdown, mental death is what they call it. What about those persons? They don't have a right to it, so people have argued that they should. But let's look in detail at the arguments of the elderly. Wesley Smith, a bioethicist, wrote a book called, which is a good read, called Forced Exit, Duty to Die, in response to the head of the Hemlock Society, who wrote a book called Final Exit. And in the book, he says that we live in an ageist society that values independence and youth. And so if you're lacking in youth, total independence, somehow we think you are lacking in the ability, you don't deserve to live. So he's saying, even if people have the best of intentions, a person who's suffering and dying may say, well, I'm a burden on my family emotionally. I'm a burden on my family financially. The woman in California who wants to die keeps saying, I don't want my daughter to come home and find me dead. I don't want my daughter to have to not go to college because she has to stay home and take care of me. So I don't want my daughter to use out of her funds because you spend more at the end of life than you spent 30 years before. And so he's saying there could be pressure for a person to die. Family members may pressure somebody into choosing the medication. There's a case of Kate Cheney in Oregon, who was a 85-year-old woman suffering from stomach cancer. She was living with her daughter. When she got her terminal diagnosis, she told her daughter, well, I heard something, because compassion and choices, they inundate people with all this literature. The advocate, they say they want to educate people and inform people. Opponents say they're pressuring people. And they're usually present at the death of the people who die. And if you can't get a physician that will go your way, they have a list of physicians that will find you to be competent and that will say that you're eligible for the medication. So Kate went to her daughter and she said, well, I'm thinking about it. I received this literature. And so the daughter said, yes, I think it's a good idea. I think you should do it. So the daughter takes her to her primary care physician, and he says, I don't think she's competent because she has memory lapses. She doesn't know what day of the week it is. There's a lot of things she can't comprehend, so she can't understand that she's going to die and all the ramifications of taking the medication. And so he said, I'm going to send her to refer her, as the statute dictates, to a psychiatrist. So he sent her to a psychiatrist. Psychiatrist agreed, said she has cognitive issues, she's not competent or capable of requesting the medication. Now, nothing in the statute says you're limited to one shot. You can keep going and on until you find a doctor who agrees with what it is you want to agree with. And that's what the daughter did in this context. So she takes her mother to a psychologist. And the psychologist said, well, I feel like she's been pressured by her daughter, and she does have some short memory concerns, but she's probably capable of requesting the medication and of obtaining and understanding the ramifications. So she gets the prescription for the medication. She puts off taking it. Her daughter says, I need some respite care, so she put her in the nursing home for a week. And every time the daughter goes to visit her, the nursing home staff said the woman begs to come home. I want to go home. So the daughter relents and takes her back home after a week, and then she takes the medication. The psychologist said, well, I was concerned, but there's no mechanism in the statute for reporting. Like when there's adult protection, there's child protection. If you suspect abuse, you have to report to an agency. There's no agency regulating this. It's in the public health department, and there's no mechanism built in the statute to report. So even though he has some concerns, so that's been a story that's been opponents have been putting forward, saying there's some ethical problems there, because if it's about choice, whose choice? If it's about making a voluntary informed decision, who's making the voluntary decision here? When you have somebody who can't remember what day it is, how are they making an informed decision about taking the medicine? Like I say, the doctor shopping is a big concern. And it's documented. At least 5 of the 15 deaths in the first year, they saw more than one doctor, and they were turned down. The doctor says, you're not competent. And they went and found another doctor says, well, yeah, you are competent. And so they were able to get the medication. And most persons who request the medication, this is another loophole in the statute. Remember when I said that in order to request the medication, your request has to be in writing and has to be witnessed, and the witnesses have to be disinterested. When you take the medication, the doctor isn't obligated to be there, and in less than 14% of the cases, the doctor's only there in 14% of the case from 2014, and that's down from 17% in the previous year. So doctors are not being there. Usually persons are now surrounded by a representative from a nonprofit organization like Compassion and Choices, and a person who is interested, an adult child or the next of kin, somebody who's going to benefit from the death. So people are afraid that since this is not being monitored after the person gets the prescription, there's nothing to stop abuse once you get the medication. There's nothing to stop somebody from forcing you to take the medication. And sometimes you may be forced to take the medication because they're looking out for your best interest. Sometimes it's not being selfish. They're thinking you're in pain, and now you're afraid. When I was in Switzerland, I talked to some doctors who said there were people who said that they didn't want to live, but they were afraid to die. But they had this medication, and, you had family members saying, it's okay, you can say goodbye, I'll hold your hand. And even to the very end, they were afraid to die, but they took the medicine. People are afraid because rationing health insurance is a big issue in the United States. The Affordable Care Act had a clause that said that they would reimburse doctors for having consultation with patients about end-of-life care. Then Sarah Palin said there would be death panels, so that was dropped from the statute, from the act. But just a few days ago, a month ago, the Medicare Medicaid program said that it would reimburse doctors through the Medicare Medicaid program who had a discussion with their patients. So you're going to get a certain amount of money you can bill for talking with your patients about end-of-life options. So people are afraid that you have a person who's, say, paraplegic, and then that person becomes terminally ill, that a doctor may say, well, they've lived all their lives with all these challenges. Why should they have to suffer now? And encourage them, say, this is your way out of all your pain and suffering, because we value some lives different than we do others. And if it comes down to long-term care treatment, the insurance company is probably going to be more willing to do the cheaper alternative. As we saw and I would give you an example of that actually happening in Oregon when I get to talking with low-income persons. Mentally ill. This is a tough one because on the one hand, the law says you have to treat the mentally ill just like everybody else. There's the American with Disabilities Act. You can't discriminate. So they should be able to choose. If somebody's paranoid schizophrenic, they should have just a right to choose physician for assisted suicide as anybody else. But the fear is that if somebody's clinically depressed, because under the statute, if you're clinically depressed, you still have a right to choose. It's only if you can prove or your doctor thinks your clinical depression is impairing your judgment. And if you were not clinically depressed, you would not ask for the lethal medication. Then that's what people are afraid of, saying the same thing with the doctor shopping. And the same thing with putting a population of people who have challenges in other areas, put them at risk through that. So, and this has been, like I say, a hard issue because persons with disabilities, their organizations and advocates, they strongly oppose this because they're saying you're putting a value on what the quality of life is, because a lot of the terminology says, well, people would like to end their life because they lose autonomy and they have poor quality of life. And you have a person who's a paraplegic saying, wait a minute, I have autonomy. What are you talking about? What is your definition of autonomy? What is your definition of quality of life? And the same way, and like I say, the mental issues are really harder because anybody who gets a diagnosis is going to be somewhat depressed. But is that depression going to impair the judgment? And you have these decisions that are not made by psychiatrists or psychologists, but by the primary care physician. So that's been a concern. Okay, this was an example in Oregon of a woman. She was what we call a working poor because she had a job and she had health insurance. But she wasn't making that much money, but her job was paying her insurance, and she got sick. She died with lung cancer. And the chemotherapy, they did an analysis. They said, well, chemotherapy is going to cost $4,000. And so she went to treatment, talked with her family, said, we're going to fight the disease, prepared, to go for the chemotherapy. And then she receives a letter in the mail saying, we won't cover the chemotherapy, it's too expensive, but we will pay for you to get a prescription for the lethal medication under the statute, because we would like to inform you that, in case you didn't know, that in the state of Oregon, that your insurance will pay for you to request a prescription. And she was just like, I don't want to request a prescription. They were like, well, we're not paying for chemo. So that's a concern, because then people are saying, whose choice is it? Is it your choice, or is it really the insurance company? So we start doing economic evaluations. In the United States, there's something called now legally called medical futility, in the sense that if your doctor say any treatment is medically futile, you don't have an opportunity to say, well, give it to me anyway. I want to fight as much as I can. If they look down the line of appropriate treatment. And in the past, the appropriate treatment would have been, this probably would have been her only treatment. So the insurance company would have paid because they would have deemed this the appropriate treatment. The problem with her is that now when the doctor sends in a code to diagnosis, there's a box at the end that says physician-assisted suicide is legal in the state of Oregon, Washington, Vermont. This is an option. This is a treatment option. Because remember, the California Act said it's all about options, right? It's just another treatment option. And people are afraid if it's just another treatment option and it's a cheaper treatment option, what do you think the insurance company is going to pay for? And then this is just another thing in the United States. It's been documented, health equity disparities. Low-income people and people of color, they get less effective treatment. They're diagnosed later in a condition. When they're terminally ill, they get less pain management because doctors tend to think that they're seeking out drugs so they don't get prescriptions like they should. The whole system is sort of set against them. So opponents have said, why, if we can't ensure that they get proper treatment, and it's documented that we can't, then how can we be sure that they won't be encouraged to self-terminate? The response to that has been, there's been no person of color in the United States that has chosen physician-assisted suicide. So a person was like, there's no person, so this is not an issue. The problem is that Oregon, Vermont, Montana, and Washington are 90+% white. The first racially diverse and economically diverse state to legalize it is California. So that's going to be the testing ground on this theory, because you can't discard it now because the majority of people who are elected in medicine are white, but Vermont is 98% white. Montana is 97% white, and the rest of them are pretty close. And last, I want to get to the groups that are excluded. So should an 18-year-old person, somebody who's younger than 18, should they have a right? Now, here are the ethical concerns. Number one, who makes the decision? Should a parent be able to decide? And if the parent is able to decide, what about caregiver fatigue? What about the fact that the parents get overwhelmed? What about their making emotionally clouded decisions? But on the other hand, what about a child? In the United States, a child is not competent to execute a will, a contract, an advance directive, because there's a presumption they're not competent. So how do we rectify the fact that we want a 17-year-old is mature enough? Doctors have argued that a 17-year-old suffering from a chronic terminal illness is not the same age, maybe the same age chronologically, but not the same age psychologically as a healthy 17-year-old. So that's being debated by whether or not minors should be permitted. What about a person with no expiration time? Person predicted to last more than 6 months. Somebody with end-stage renal failure on dialysis. Some have argued that at the end of the stage, if you're in the final stage and the next stage is death and it's irreversible, why are you not terminal? What is the magic about having to die? Because, and this is another thing, you have to be able to ingest the medicine yourself or you can't take it. So a person with Lou Gehrig's disease are requesting the medicine sooner than they would, maybe, because they want to make sure they can do it while they still swallow. So that's another concern. Like I say, the person with severe dementia, Alzheimer's, where do they fit into the whole category? And it's about, I have about 15 minutes for questions.